Good morning, everyone.
Good morning.
Each side will have 15 minutes to present their arguments to the court. The appellant may reserve up to 5 minutes for rebuttal time if they so choose. And when you're ready, we're ready to proceed.
May I reserve 3 minutes for rebuttal?
Yes, you may.
Thank you.
Thank you.
Good morning, council.
Good morning.
May it please the court, I'm Nicole Coppage on behalf of the state of Ohio and the Ohio Attorney General. As the second district recently held, amended Senate Bill 342 is constitutional in its entirety. While that case is pending a certification by the Supreme Court on jurisdictional issues, we do believe that the second district appropriately held that the bill in its entirety is a general state law and is therefore constitutional under Ohio's Home Rule Amendment, and that the trial court here erred in enjoining and declaring 3 of those provisions unconstitutional. It's undisputed that the Home Rule Amendment provides municipalities with the authority to adopt police, sanitary, and similar regulations within its limits, so long as they do not conflict with a general state law, and that's the issue here. The issue presented by this appeal is that the enjoined provision, is whether or not the enjoined provisions are indeed general laws, and it's the state's position that they in fact are. The trial court held, and the city has not contested, that the provisions do satisfy the first 2 prongs of the Canton versus state general law test, in that those provisions are part of a statewide and comprehensive legislative enactment and apply to all parts of the state and operate uniformly throughout the state. We believe that the trial court erred in finding that those provisions, evaluated those provisions in isolation to find that they don't satisfy the 3rd and 4th prongs of the Canton general law test. First, the 3 enjoined provisions do in fact set forth police regulations rather than purport to only grant or limit municipal authority. The inquiry under the 3rd prong is not whether a state simply limits municipal power, but whether it does more than limit municipal power. And here, when we look at the enjoined provisions in the larger context of the bill, as the Supreme Court has directed one is to do, those provisions are in fact part of a comprehensive statewide scheme intended to uniformly regulate the operation of traffic cameras. Here, looking at the bill as a whole, in addition to the provisions that have been joined, it sets forth a number of regulations on both municipalities and citizens, as well as insurers and manufacturers, setting forth uniform operation and implementation of traffic camera monitoring devices. For example, it includes provisions that insurers may not deny coverage or decrease premiums based on a civil citation. It sets forth the requirements for a citizen who's been issued a civil citation to either pay or challenge that civil citation. It sets forth hearing requirements to contest those civil citations, including standards of proof. It sets forth the requirements for a registered vehicle owner to dispute or contest a civil citation where they've been cited based solely upon registration of a vehicle. And it sets forth requirements, among other things, for manufacturers to provide maintenance records for cameras and annually certify proper operation. So viewed in its entirety, the bill does in fact set forth regulations upon municipalities and citizens, as opposed to simply limiting a municipality's authority. And in addition, the provisions, as well as the bill in its entirety, do serve a legitimate statewide interest in ensuring that these traffic cameras are in fact implemented uniformly from jurisdiction to jurisdiction. This interest has been demonstrated by subsequent case law or by subsequent state laws and is nothing new to the state of Ohio. For example, state law also sets forth requirements on how municipalities may erect other traffic control devices. There are state laws that direct how a municipality, peace officers, what their uniform standards. There are state laws in existence prior to this bill that set forth the specific markings that must be on a police officer's vehicle if they're going to enforce traffic violations. And even prior to Senate Bill 342, there was a state law in place that directed how local authorities may deploy these traffic camera devices. So this concept of ensuring uniform and uniform operation across each jurisdiction within the state is nothing new here. And looking at the bill as a whole satisfies the third prong of the Canton test. In its briefings, the city relies heavily on the case of Mendenhall versus the city of Akron. That case is not dispositive here and in fact supports the state's position in that Mendenhall actually found the state statute at issue, Ohio's speed limit statute, to be a general law. The issue at Mendenhall was that the court found that Akron's ordinance at the time did not conflict with any general state law. Here, there is a conflict, and therefore, under the provisions of the Home Rule Amendment, the Akron provisions must cede to the state law provisions. In addition, the enjoined provisions, as well as the bill in its entirety, satisfy the fourth prong of the Canton general law test. State law, to be a general law, must apply to all citizens generally. Here, the trial court erred in viewing the three enjoined provisions in isolation. Again, the Supreme Court has said in previous case law that we must look at those provisions in the entirety of both. We look at with them within the context of the bill and within the context of the larger statutory scheme. Here, as I've previously indicated, there are a number of provisions within the bill that apply to both municipalities and to citizens alike, insurers and manufacturers. In addition, the bill itself is part of a much larger state statutory scheme regulating uniform traffic regulations across the state, being Revised Code Chapter 4511. And that chapter in and of itself certainly applies to citizens generally. And again, this is nothing new. The Supreme Court has looked at similar provisions in cases like Cleveland versus State, where there was a ban on municipality firearm regulations, where the court held that you had to look at it in the larger context of Ohio's firearm statutory scheme. In Claremont versus Weiderholder, the court looked at a state statutory scheme in which regulations related to hazardous waste materials were actually part of a larger scheme that regulated across the state the disposal of hazardous waste materials. And similarly, in American Financial Services, the state considered a general law a state lending predatory law, which applied to not only municipalities but also applied to lenders and those who might be getting loans. So again, we believe that the trial court erred by simply looking at the three enjoined provisions on their own without considering the greater context of the bill.
Let me ask you a question. Where do you draw the line? The Ohio Constitution says municipalities shall be authority to exercise all powers of local self-government and to adopt and enforce within the limits such local police regulations that are not in conflict with general laws. Isn't it possible that the state of Ohio can pass so many general laws that there's no ability for any municipality to exercise any power? Because they've been overregulated before, they have no authority to do anything. I mean, the law already says you can only go 25 in the school zone, 20 whatever it is. Okay? Now we're telling you, here's how you enforce that 20 miles an hour in that school zone. I mean, you can micromanage this down to the point where you say that policeman who's going to stand there next to that machine has to have a hat on with the brim this wide. How far are you going to micromanage this?
Sure, I understand, Your Honor, and I, from the context of when regulations might end, I certainly couldn't speak to that. My response would be here, what we're looking at is, again, the definition with the Canton versus State general law test that the Supreme Court has set forth as to whether or not this particular regulation is a general law, and we believe that it is. And therefore, we do believe in this case that the city ordinances should see to those provisions.
Well, what are the material differences between them? What are we fighting about?
Here, I believe that the issue here is, while it is our position, our view, and if you, in reading Senate Bill 342, municipalities are permitted to operate traffic cameras. What we believe the state is doing is simply setting forth regulations on how they do that. The dispute here seems to be with respect to the particular regulations. Here, Akron, and certainly anticipate they will speak to that, would like to do so unimpeded. And our view under Canton versus state and Ohio's Home Rule Amendment is the state has the authority and the ability to set forth regulations that ensure that motoring citizens can expect some uniformity and regularity as they travel from jurisdiction to jurisdiction.
Counsel, I apologize to you. Did you say 3 or 5 minutes you wanted to say?
3.
That's fine. Go ahead. You're fine.
But I've concluded my initial presentation, so if you have any other questions, or I can reserve the rest for rebuttal.
I think we can reserve it. Thank you.
Thank you.
Good morning.
Good morning.
May it please the court, Attorney Christopher Reese on behalf of the Appalachia City of Akron, in this case, with me at the table, Sarah Rathke. She's counsel for a co-Appalachia American Traffic Solutions. I'm going to start the argument by putting this in this home rule issue, I think, in very simple terms, and it plays on a history of what's happened with the Ohio State Legislature. The Ohio State Legislature does not like photo speed or photo traffic enforcement cameras. There was a bill proposed and passed and sent to the governor which outright banned them. And Governor Kasich, Governor Taft, vetoed that bill. So that sets the stage for the Ohio Legislature to decide what to do now. The Mendenhall case and the Walker versus City of Toledo case then were decided, which gave cities under home rule authority the constitutional authority to operate civil photo traffic enforcement systems. So now the Ohio State Legislature says, well, we realize we can't tell them not to do it. They set upon a course to try to tell municipalities how to do it. And that is where Senate Bill 342, the bill that's at issue in this case, that's how that bill gained life. That bill, in its entirety, from top to bottom, from start to finish, every provision in it sets restrictions, requirements, prohibitions on a municipality of what they have to do and can't do in order to operate a photo traffic enforcement system that they're entitled to operate pursuant to the Ohio Constitution. One of the things in that Second District Court of Appeals opinion that's disturbing that was decided in August was the Second District Court of Appeals says, well, the Senate Bill 342 permits cities to operate photo speed or photo traffic enforcement systems. That's not true. Senate Bill 342 does not permit cities to operate these photo systems. The Ohio Constitution gives them that authority. So in that regard, the Second District Court of Appeals was incorrect. Now, that opinion came out...
So you're saying they started from a faulty premise?
Correct. In
what
part.
about the fact that the trial court here below really didn't take... Any court reviewing any state statute has to start with the fact that it's presumed constitutional.
Correct.
And if you didn't start from that premise, how does that affect this decision?
How does it affect the trial court's decision?
If we're talking about faulty premises, so I'm just wondering if the trial court doesn't start from the premise that the statute is presumed constitutional.
I believe, I read the trial court's decision to say it did start with that premise. You know, when you start with that premise...
I'll read it again, but I didn't see it in there. Maybe he was thinking that.
Now, the Second District Court of Appeals opinion was decided in August, and the timing of it was decided after the briefing closed in this case. So it was, as the court is well aware, it was submitted as supplemental authority, so that the city, the appellees haven't had a chance to address the opinion yet. So I'm going to spend a portion of my argument not rehashing what's in our brief, but about the Second District Court of Appeals opinion in this case. Interestingly, what's in the Second District Court of Appeals opinion at paragraph 28 is an interesting holding. This has been broken down by the Second District Court of Appeals as the contested provisions and the other provisions. The contested provisions being the ones that our trial court, the Summit County Trial Court, ruled on. It's the officer being present at the scene, it's the public information and studies as a prerequisite to operating one of these, and it's restrictions on what speed limits you can cite people for. Those are the contested provisions. Oddly enough, or interestingly enough, the Second District Court of Appeals at paragraph 28 said that those three provisions undoubtedly regulate the requirements and implementation procedures to which a municipality must adhere if it chooses to use these. What the Second District Court of Appeals held was those three contested provisions violate home rule. So the trial court below was correct in its ruling. So if the sole issue before this court, if this court believes that the sole issue on appeal right now is whether the Common Police Court in Summit County correctly ruled that the three contested provisions violate home rule, I submit to you that we argue that they do, and we spent a good portion of our brief arguing that they do, but the Second District Court of Appeals actually said they do. So if that's the issue, if that's the sole issue before this court, then the court must affirm the trial court that these three contested provisions violate home rule. What's disturbing about the Second District Court of Appeals is what their holding was okay, you can pass three provisions that violate home rule, and you can wrap them around these other 6 or 7 or 8 provisions that arguably don't violate home rule, and everything's okay. And that's where I think, Judge Schaefer, you might have been touching on when you asked the question, where does it end? Where do you pass one huge violation of home rule? You say, there must be a police officer present on every street corner in the city of Akron, but in that same bill, you wrap it around some other innocuous provisions that don't impose restrictions on municipalities. And under the Second District Court of Appeals reasoning, you have to look at the whole bill, and if some of it doesn't violate home rule, then we'll brush off the one that does. Well, that's what they did. They brushed off the 3 that do in this case. And I'm telling you, I'm representing to the court, the 3 of them that violate home rule are the essence of this bill. Okay, it tells you what you need, it tells a city what it needs to do before it implements one of these. It tells them how they have to do it, put a cop at every box, and it tells them what speed limit they're allowed to enforce. Those 3 provisions are the essence of Senate Bill 342. Now, the other provisions, so to speak. It is the appellee's position in this case that the Second District Court of Appeals was incorrect when they succinctly and in 2 lines in the same paragraph 28 said, well, there's other provisions here that don't impose restrictions or requirements on municipalities. They impose or establish procedures for motorists to follow when they get one of these. I submit to the court that is inaccurate. That is not an accurate holding. I have read, and I urge the court to read those other provisions closely. They may be written creatively like they impose a rule of conduct on citizens, but they don't. They're just written that way. 094 talks about signage. That imposes a restriction on a city and tells a city what signage they need to put out to have one of these. 096 dictates to a city that a law enforcement officer has to examine every ticket. 097 is one that sticks out with me. 097 says that if a city operates a photo enforcement system, a ticket must comply with the following requirements. I'm thinking, a ticket? Okay, you can only impose obligations on the city or obligations on the citizens. That section's written that imposes obligations on a ticket. What that effectively says when you read it is, when a municipality makes a decision to operate a photo traffic enforcement system, its ticket must comply, it must comply with the following requirements of the ticket. That is, in effect, telling a city what it has to include in a civil ticket. It's not even a ticket, it's a citation. 098, supposedly that, according to the Second District, imposes procedures for motorists to follow. No, it doesn't. 098 talks about the rights of those ticketed and the defenses they're allowed to raise at a hearing. How does that impose a rule of conduct on a citizen? That tells a city, here's the rights of the person you need to recognize who issued one of these citations, and here's the defenses you need to recognize. That's what that section tells a city. And finally, 099. One of the most disturbing ones. You know, the Walker case held, the Walker versus Toledo case held that when a city operates one of these civil traffic enforcement programs, it has the right to determine the administrative hearing, how they want to conduct an administrative hearing, how they want to appoint the officer, how they want to conduct the hearing. Do they want to conduct it in a courtroom or in the basement? Do they want to? That is a city's home rule authority to determine how and when and what to do as far as an administrative hearing goes. And 099 dictates, imposes, tells a city how to appoint their hearing officer, how to conduct their hearing, what evidence you must consider. That's a violation of home rule. The Second District Court of Appeals too quickly and too hastily said that these other provisions, so to speak, that I've referred to, are not violative of home rule. Our trial court did not rule that. One of the issues in this case early on was, should this case be remanded back to the trial court and let the trial court decide whether those other provisions also violate home rule, which would be an issue that we would argue certainly they do for the reasons I just listed. But nevertheless, why we're here today is because the trial court decided to rule on the three provisions that are, again, the essence of Senate Bill 342. Those three provisions determine whether a city is going to operate one of these. You know, signage, what's in a ticket, those things a city can substantially comply with. You know, so we change a ticket. So we put a couple more things in a ticket. So, you know, we hold a hearing in a different way. Those things don't destroy the system. Those things aren't a roadblock to operating one of these. But I'm telling you, the three systems, the three sections that are the contested provisions, those dictate whether a city is able to operate one of these. If you have to have a police officer present in the city's case, in the city of Akron's case, at the scene of every one of the school zone cameras, the city of Akron is not going to operate this system. It just simply isn't, due to budgetary constraints and other reasons. But I tell you, the other cities who have, you know, 30, 40, how many cameras at red lights or speed cameras, they also make the same argument. They are not going to be able to put a police officer present at the scene of every one of those. These public information campaigns and these safety studies, those are so, arbitrary and unreasonable to comply with that no city is going to be able to comply with such a study. You know, in the city's case, I think, what study? Study that people speed in school zones? You know, this system came about because a school child got run over in a school zone. You want to study? There's a study. You know, but according to this law, the city of Akron is going to have to sit down and hire a consultant and go out there and watch cars and do speed limits and conduct studies. For what? Slow down in a speed zone, in a school zone. That's your study. Those things are the things that are, again, the essence of Senate Bill 342. But I submit to you, even if you want to accept the Second District Court of Appeals reasoning and say this whole thing must be ruled on in its entirety, which I'm not sure is before this Court of Appeals at this point, arguably the only issue before this Court of Appeals is whether the three critical provisions, the contested provisions, were properly ruled upon by the trial court. That may be the only issue before this court. That needs to be affirmed. Those violate home rule, and the Second District Court of Appeals said they did. The other thing that's disturbing in this Second District Court of Appeals opinion is paragraph 29.
Counsel, I just want to make sure.
Sure.
The other applicant doesn't.
I don't think she's going to reserve any time.
Okay, all right. Just wanted to double check that. I apologize.
I could yield to her. She's maybe more eloquent than paragraph 29. And paragraph 29 talks about, you know, in the opinion that, well, in Mendenhall, they recognize that if you enact a comprehensive and statewide legislative scheme directed at the conduct of motorists or citizens in general, then you're allowed to go ahead and set forth specific procedures and limitations on municipalities. And they said, thus, if they can do that with regard to the speed statute, why can't they do that in this case? Why isn't this some sort of statewide comprehensive legislative scheme where they're allowed to impose all these restrictions on municipalities? There's a very short and quick answer to that. Because they did not. The state legislature did not enact a statewide comprehensive legislative scheme directed at the conduct of citizens. I'll give you two statutes where they did. You know, some time ago, the state decided, you know what, we want to control the OVI laws in this state. So they enacted an OVI statute. And the very first line says, no person shall operate a motor vehicle while under the influence, to paraphrase it. When you start out a statute that says no person, that is imposing a rule of conduct on citizens in general. Then you're allowed, under Mendenhall and what the Court of Appeals in the 2nd District said in paragraph 29, then you are permitted to go ahead and put on all these OVI restrictions on municipalities because you have first enacted a statewide comprehensive legislative scheme directed at the conduct of citizens. The same thing they did in the speed statute. It says no person shall violate the speed laws in the state. That's the very first line of 451121. The rest of these pages are restrictions on cities' ability to set speed limits. Why are they allowed to do that? Because they first enacted a statewide legislative scheme directed at the conduct of citizens. That is absent in this case. This statute, or this bill, Senate Bill 341, it doesn't start out, no person shall violate the traffic laws of a city in a zone that is being policed by photo traffic enforcement systems.
And also you're out of time.
Had they started it out in that regard and started out with that general language directed at citizens' conduct, then they could have imposed these restrictions on municipalities. But they didn't, and they didn't for a simple reason. They don't endorse it. Then they would be endorsing it. And the state legislature does not want to endorse this. They want to restrict it. They want to tell municipalities how to do it instead of endorsing it with a general law directed at the conduct of citizens. Thank you.
Thank you. We have almost 5 minutes left.
I just want to touch on a few of the issues that have been raised. And to begin, intent is not the issue here. We are looking at the Canton General Law test. While, whether the argument is whether Akron or other cities would continue to operate these traffic cameras in light of the enjoined provisions is not the issue here. The concerns with whether or not they can continue to comply or are able to comply with these provisions is an issue that the cities can take up with the General Assembly, but it's not appropriate for this analysis, as the Supreme Court has already held. Just to touch on that point with respect to whether or not cities can or cannot operate, it is in the record below that in fact after the bill went into effect, two cities, the cities of Hamilton and Parma, did continue to operate their traffic camera systems. So it's certainly something that's possible, but again the state's position is that shouldn't be a factor in this analysis. The analysis here is whether or not the bill is a general law, and here it is in fact, and therefore the Akron ordinance must cede to those provisions. With respect to the 2nd District decision, while the city may parse out provisions and sentences within that decision, the 2nd District very clearly set forth that the bill in its entirety, including the 3 enjoined provisions that are at issue here, are in fact constitutional. And that was the ultimate holding in that case. There is no dispute that those provisions, or there should be no dispute that the court found those provisions to be constitutional under the Home Rule Amendment. Contrary to the city's contention, the mere fact that a general state law requires municipalities to take certain actions and refrain from others, that in and of itself does not violate the Home Rule Amendment. And again, what the city's arguing is that these 3 provisions be looked at in isolation, and the Supreme Court has said a number of times that they cannot be considered alone. They must be looked at in the greater context of both the bill, which the trial court has already set forth is part of, including the 3 enjoined provisions, a comprehensive statewide legislative enactment, as well as the overall legislative scheme that the bill's been placed in, which is again Ohio's traffic enforcement laws. Citizens are certainly affected when we look at the bill as a whole and all of the separate provisions that have been addressed. Citizens are certainly affected and impacted by the procedures that are set forth within that bill. When we're talking about ticketing requirements, certainly those requirements set forth expectations for motoring citizens as to what they can expect if they're to be cited with a civil citation and how they are to handle those. Those absolutely apply to citizens and have a direct impact on how they're going to respond to these civil citations and not simply on what the municipality must do. And the final issue that I wanted to address was the city does raise a question as to what is actually on issue at appeal here, whether it's the 3 separate provisions or the bill in its entirety. And the state would submit to this court that we agree the limited issue on appeal is whether or not the 3 enjoined provisions are constitutional, because the court has already determined that the remaining provisions in the bill are in fact constitutional. And we believe that that's the issue. We think that this court should determine that those 3 remaining provisions are in fact constitutional, and as a result, amended Senate Bill 342 in its entirety satisfies the requirements of the Home Rule Amendment and is constitutional.
Thank you, counsel. Thanks to both sides, I should say, and the court will take the matter under advisement. A written opinion will be issued and sent to both sides, and you can look on the Supreme Court website and our own website with the 9th District. And we are adjourned